Good evening, everyone. Thank you guys for being here. What we're going to do this evening, we're going to start from the beginning of the Eastern District of New York trial for Robert Sylvester Kelly. And we're going to give you the real truth of what happened in court. We're going to start from the beginning, which is August the 18th. And we're going to have every individual in here playing a part so you guys could get full of understanding of what occurred on at the trial in New York. So we're going to thank the individuals who decided to give up their time to reenact this. We're going to thank Nakia. We're going to thank Miss Henny Hen, Miss T. London, Miss Rhoda, Miss who else? Miss Unique Thought. We're gonna thank everyone. They have taken the time out to, guys, delete that person out of here, please, guys. Delete them out of here. Let's make sure anybody that's being disrespectful gets booted out of this channel, please. Everyone, please put yourself on mute until it's time for you guys to come in, all right? Okay, 1 second. All right, we're getting ready to share this channel here. Just bear with me. I'm going to put up the link for you guys to be able to see what we're reading from. Okay, just 1 second. All right, you guys ready? Ready, chat?
Yes.
All right, guys, here we go. We get ready to reenact everything that happened at trial. Let me just open this up. And it's the United States versus Robert Sylvester Kelly. And the date is Wednesday, August 18th. And we're getting ready to get started. All right, let's get started. Let them roll.
Hello?
We're ready.
Can you guys hear me?
Yes, we can.
Yes.
Okay, she must be having issues with her connection. I'm going ahead and read this, and I'm going to go ahead and boot her out and let her come back. All right, let's go. Eastern District of New York, and the Honorable Judge Ann Donnelly is presiding over this case, and the proceeding starts, and let's start with the court reporter. Thank you.
All right. Good morning, everybody. You can have a seat.
This is criminal cause for trial, docket number 19 CR 286, USA versus Robert Kelly. Counsel, state your appearance. Government first.
Elizabeth Geddes, Nadia Shahada, Maria Cruz Melendez for the government. Also seated at council table is paralegal specialist Kyrie Winton and Special Agent Ryan Cobot with the Department of Homeland Security Investigations.
You're not done.
Good morning, Your Honor.
Good morning.
Good morning, Your Honor. Nicole Blank Becker, Calvin Scholar, Deborah Ricks Canick, my client, Mr. Kelly, and Mr. Tom Farinella, on behalf of the defense, and we are ready to proceed.
Okay. Good morning, everybody. Just a couple of preliminaries before we begin. First, I want to remind everybody to microphones on both sides so that people in the overflow room can hear. With respect to the outstanding motions, these will be followed by written motions. The motion to dismiss is denied in all respects. I have an exception to that ruling. As I said, there will be a written decision filed shortly. With respect to the outstanding motions in limine, I adhere to my decision that I made at our final pretrial conference on August the 3rd. But let me review the outstanding motions in limine and let me know if I've forgotten one. The first has to do with the alleged sexual abuse of Jane Doe number 7, a minor, in 1991. That is granted only insofar as there is evidence that Jane Doe number 7 witnessed the alleged sexual abuse of Jane Doe number 1. That's admissible for the same reasons that I ruled that evidence about Jane Doe number 1 was admissible. The remaining evidence is not admissible about Jane Doe number 7. The conduct is alleged to have taken place before the enterprise began, so I'm excluding that. The second category of evidence is the alleged sexual abuse of Jane Doe number 9, a minor, in 1995. Evidence that Jane Doe number 9 informed the defendant she contracted herpes from him is admissible. It goes to knowledge for the charged acts in Racketeering Acts 12 and 14, as well as in counts 6 through 9. The evidence is not unduly prejudicial and no more sensational than the conducts that's charged. The other allegations regarding Jane Doe number 9 are not admissible. The third outstanding motion in limine was the alleged exposure of Jane Doe number 11 and 12 to a sexually transmitted disease in 2001. The evidence that Jane Doe number 11 informed the defendant that she contracted herpes from him is admissible for the same reasons that I just described with Jane Doe number 9. The evidence of the settlement agreements with victims is also admissible. It is direct evidence of the enterprise and the means and methods, specifically the steps that the defendant and other members of the enterprise took to conceal what was going on and to perpetuate the enterprise. The next category is the alleged unlawful imprisonment of Jane Doe number 14 in 2008. That is admissible. It is not unduly prejudicial. It is direct evidence of the enterprise and its means and methods. The only other issue was this question of whether the parties were going to stipulate to the dates of concerts that took place. What was it, in Georgia?
Yes, Your Honor, in Georgia.
Did you stipulate to that?
It's my understanding that defense counsel is going to stipulate to all of the dates, with the exception of the one newspaper article the government sought to admit that showed that Demetrius Smith was present at one of the concerts in a way that would directly corroborate Mr. Smith's anticipated testimony regarding Racketeering Act number 1.
Are you going to deny that he was? Is the defense going to deny? I don't know who this person was, but are you going to deny that he was there? Just use the microphone, okay?
Thank you, Judge. Judge, it is not a question of whether we're going to deny that he's there. It's a question he's going to take the stand. So we think the best evidence will come when he takes the stand. They can just ask him that question.
Well, that's my question. Are you going to challenge his testimony that he was at the concert? It seems of vanishingly small importance to me, I have to say. There's an article that he was in at this concert. If you're going to dispute that he was actually there, I will let the prosecutors introduce evidence from the newspaper. It's up to you.
Your Honor, one moment.
Thank you, Judge. Judge, at this point, we are not going to stipulate to that. We are going to challenge that.
Okay. So if he testifies that he was there and he's cross-examined on it, the government can introduce the newspaper article showing that he was there. I think that's it. So let me just say that in the opening instructions to the jury, I'm going to just describe in general terms what the case is about, just as I did when we selected the jury. I used that same language that I used then. Oh, and I know what the other thing was. The question about whether Jane Doe number 5 could testify. Did I already rule on that? That she could testify using a pseudonym?
Yes, Your Honor. I believe you ruled and you approved her testimony.
That's what I thought. All right. I think it is probably appropriate to include a general instruction that some witnesses will be testifying by their first names and explain that the reason is that this is not uncommon in cases like this, where they might be testifying to things that are potentially embarrassing. Okay? And just remind me, is one of the witnesses testifying, I don't know what to call it, using first names or
Nicknames?
Or nicknames. Okay. All right. Anything else that anybody wants to raise?
No, Judge.
All right. I think we are ready for the jury.
All rise. Everybody be seated.
Good morning, ladies and gentlemen of the jury.
Good morning, Your Honor.
We're about to begin the trial in the criminal case for which you were all selected as jurors. I'm going to give you some preliminary instructions and also give you an overview of what will happen during the course of the trial. Your job as jurors is to administer justice in this case according to the law and according to the evidence. You must carry out your duties as jurors with complete fairness and impartiality and without bias, prejudice, or sympathy for either side, either for or against the government or for or against the defendant. I'm going to give you a summary of charges. Again, this is just a summary of the charges. It is not evidence. The defendant, Robert Sylvester Kelly, is charged with racketeering in violation of Title 18, United States Code Sections 1962, Paren C, and 1963, for his alleged role as a leader of an enterprise. He is alleged to have engaged in racketeering acts that include bribery, sexual exploitation of a child, kidnapping, transportation of minors, and other people for the purpose of engaging in illegal sexual activity, illegal coercion, and enticement of individuals in forced labor. Mr. Kelly is also charged with violations of the Mann Act, including the transportation of individuals, including a minor, for the purpose of engaging in illegal sexual activity and illegal coercion and enticement of individuals, including a minor, in violation of Title 18, United States Code Sections 2421, Paren A, 2422, Paren A and B, and 2423, Paren A. Mr. Kelly has pleaded not guilty to all of the charges. It is the government's burden to prove Mr. Kelly's guilt beyond a reasonable doubt with respect to each charge. As I told you when you were selected as jurors, the indictment is the document that brings the case to court, but it is just an accusation. It is not evidence of anything. The government has the burden of proving, as I just said, each of the essential elements of each crimes that charge beyond a reasonable doubt. The purpose of the trial is to determine whether the government has met this burden. A defendant in a criminal case does not have to prove innocence. On the contrary, the defendant is presumed to be innocent of the charges in the indictment. One of your jobs as jurors is going to be to determine what the facts are based on the evidence. You, as jurors, are the sole judges of the facts. You will then have to apply to those facts the law as I will give it to you, and you must follow the law regardless of whether you believe in it or not. Because I am the judge of the law, I will make legal rulings, including on objections, or I may direct the lawyers to move along so we can keep the case moving. Do not assume that because I make a ruling that I have some opinion about the case or what your verdict should be. I don't have any such opinion. Sometimes during the course of an examination, I will ask the question of a witness. If I do that, it's either because I don't understand a particular question or because I think somebody needs to be clarified for you. Again, don't assume that just because I asked a question that there is some importance to it or that I have an opinion about the case. As judges of the facts, you will listen to the evidence. The evidence consists of the testimony of witnesses on direct examination and cross-examination, documents and other exhibits that come into evidence, and any facts on which the lawyers agree. These are called stipulations. There are other things that are not evidence, and you may not consider them. What any lawyer says during the course of a trial, whether it's an opening statement or if it's in an objection or if it's in summation, is not evidence. With respect to objections, lawyers do have an obligation to make objections if they think there's a reason to object. Do not hold it against lawyers if they do object. That's part of their job. If I sustain an objection, it means that I have determined that the question is not a valid one, and you should ignore the question. If I overrule it, that means I have determined that the question is proper. Sometimes, as a witness will answer a question, even though I have sustained an objection. If that happens, I will just instruct you to disregard the answer. Another thing that is not evidence is anything that you have heard outside of the courtroom or seen outside of the courtroom. You must decide this case only on the evidence that is presented here during the trial. As I told you during jury selection, there will undoubtedly be press coverage of this case. You must not read, watch, or listen to any reports in any form about this case. Now, I'm just going to talk to you a little bit about one of your tasks as jurors, which is to determine the credibility of the witnesses who testify, determine whether or not you believe what the witness is saying, whether you believe the witness is telling you the truth, whether you believe the witness is lying, whether you think the person is being accurate, or whether the person has made an honest mistake. There's no magical test to deciding whether a witness is credible. You bring to this process your common sense, and you make these decisions all the time in your lives when you're trying to decide whether what someone is telling you is accurate and believable. I'm going to suggest some of the things you should consider when you're listening to a witness testify. What is the witness demeanor? Does the witness testimony make sense? Does the witness have a reason or a motive to testify falsely? Is the witness testimony consistent or inconsistent with other evidence or testimony. If there are inconsistencies, are they important and related to important facts, or are they minor? Has the witness said something contradictory at another time? As I said, these are just some of the tests that you use to determine whether a witness is telling you the truth or is mistaken or being accurate. Now, there are 3 rules because this is a criminal case that you must keep in mind. First, that the defendant is presumed innocent until the government has proven him guilty. Second, the government has the burden of proof. The defendant has no burden to prove his innocence or to present any evidence. He has no burden to put on a case or to testify. If the defendant does not testify or put on any evidence, you may not hold these facts against him. Third, as I have said a couple of times during the course of these instructions, the government must prove the defendant's guilt beyond a reasonable doubt. I will give you further instruction on this concept later, but this is one of the things that makes a criminal case different from a civil case. A few words about your conduct as jurors. Because you are deciding this case only on the evidence that is presented in the courtroom, that means you may not conduct any independent research about anything having to do with this case, not with the people that are involved, not with the law, or anything having to do with this case. In other words, do not look anything up on the internet. Do not research the lawyers or any witness or the parties. Do not try to find out any information about this case from any source outside of the courtroom. Do not Twitter about it. I'm not even aware of all the means of social media, but don't use any of them to communicate about this case, to express an opinion about this case, or to read about other people's opinions about the case. Related to that, you are not permitted to discuss the case with anyone during the trial. Until you retire to the jury room to deliberate and reach a verdict, you are not permitted to talk about the case. That means you can't talk about it with your family and friends, and it also means you can't talk about it with your fellow jurors. And I think I said when you were selected as jurors, that's probably a lot harder because this is the only thing that you have in common. And it's probably very tempting after a witness testifies to share your thoughts about what the witness said or to talk about something that happened in court. But you can't do that. If you were to start talking about the case before you've heard all the evidence and before you've heard my charge on the law, you would be deliberating prematurely, and the law doesn't permit that. So don't talk about the case. None of the lawyers or the witnesses in this case are permitted to greet you or to say anything to you at all. I think I told you this when you were selected as jurors. So don't think they're being rude. They're just not permitted to talk to you. You must report directly to me any effort by any person to influence you improperly or to influence another juror improperly. Any related to all, this is that you cannot form any opinion about the case until all of the evidence is in. Keep an open mind until you start your deliberations at the end of the case. Now, I think all of you have notepads. You may certainly take notes if you wish during the course of the trial. But if you do take notes, make sure that it doesn't interfere with your ability to listen to the evidence. Our court reporters take down everything that everybody says. And if you need to have some testimony read back, you can do that at the end of the trial. So that is the accurate record of the trial. If you do take notes, don't discuss them with anyone before you begin your deliberations. You will not be permitted to take them home with you. They will be collected at the end of each day. And if you decide that you don't want to take notes, that's also completely fine. But you can't rely on anybody else's notes because, as I said, The notes are just for the individual juror. As I said, during deliberations, you will be able to request portions of the trial transcripts if you need to have your recollection refreshed about evidence. So the last thing I'm going to talk to you about is just an overview of the trial. The government will make an opening statement, which is really just an outline of the evidence to help you understand the evidence as it comes in. It's what the government expects the evidence to prove. Defense counsel may, but does not have to, make an opening statement. Again, opening statements are designed for the parties to tell you what they expect the evidence to prove. After opening statements, if the defense counsel chooses to make one, the government will then present its witnesses, and counsel can cross-examine them. Following the government's case, the defendant may, but again, does not have to, present witnesses or to put on a case. After all of the evidence is in, the lawyers will have the opportunity to address you in closing arguments. And after that, I will instruct you on the law, and then you will retire to deliberate on your verdict. So I think we're ready to begin. Let's begin with the opening statement by the government. You know, I forgot to add one thing that I want you to keep in mind. It may be during the course of the trial that witnesses testify with either a nickname or by their first names. That is not unusual in a case like this that has a lot of press attention, and the witnesses may be testifying to things that are very personal and potentially embarrassing. All right? I'm sorry. Go ahead. Government opening statement.
This case is about a predator, a man who for decades used his fame, his popularity, and the network of people at his disposal to target, groom, and exploit girls.
Can you talk a little louder, please? I'm sorry, a little louder.
Gratification. A man who used lies, manipulation, threats, and physical abuse to dominate his victims and to avoid accountability for years, using his money, his clout, and his public person to hide his crimes in plain sight.
That man, that predator, is the defendant, Robert Sylvester Kelly, more commonly known as RKelly. Good morning, ladies and gentlemen. My name is Maria Cruz Melendez, and I am an assistant United States attorney in the Eastern District. These are my colleagues, Elizabeth Geddes, Nadia Shahata. They are also Assistant United States Attorneys. Special Agent Ryan Shabat of the Department of Homeland Security Investigations, and Paralegal Specialist Kyra Winthen. Together, we represent the United States in this case. During the course of this trial, you'll learn that the defendant has surrounded himself with a team of people made up of dedicated employees and close associates. These people form the defendant's inner circle. Now, over a period of decades, the members of the defendant's inner circle change. But at any given point, all of these people had this in common. Their purpose was to promote the defendant's music and brand. That is his public persona as RKelly, and to fulfill each and every one of the defendant's wishes and demands. They served him. They were loyal to him, and you will learn that the defendant used that inner circle as his means to a criminal end. Now, in the early 90s, the defendant was an up-and-coming recording artist in the R&B industry, known as R. Kelly. As his success and popularity grew, he put out multiple records and toured around the country. He performed alongside other well-known artists and eventually began headlining in his own concerts. And as a part of his career, he also began writing and producing music for both new and established artists. What this success and popularity brought him was access to girls, boys, and young women attending his concerts, access to young aspiring artists who hoped for a chance to work with him, and access to fans who looked up to the defendant and jumped at the chance to meet him or just to be around him. And the defendant quickly learned that he could take advantage of his access. And he did. At his concerts and other locations like the mall or the local McDonald's, the defendant had his pick. He had his pick of young fans in cities around the country, eager to meet him, to get his autograph or a picture. And when he found a girl, boy, or young woman he liked, he either approached them himself or had one of the members of his inner circle do it for him. They were given backstage passes or invitations to after parties and a number where they could reach the defendant. Or he got their contact information. And once they communicated via phone or text message, he invited them to visit him at his home or at his studio or to travel to see him at other performances. He directed his employees to arrange and pay for their travel so that they could come and see him. And when he had them alone with him, he used them to exert power over them, to dominate and control them physically, sexually, and psychologically. And let's be very clear, ladies and gentlemen, this case is not about a celebrity who likes to party a lot or about the defendant's own private sexual preferences. The real issue here, the reason that we're here today, is because, as the government will prove during this trial, the sexual conduct at issue in this case was illegal. It was illegal because in many situations, the defendant engaged in sex with minors, boys and girls under the age of 18, some even in their very early teens. And when he was having sex with these minors, he often recorded it using video cameras, iPads, or smartphones to produce child pornography. He also transported some of these girls and women across state lines and sexually fondled them while they were not able to consent and exposed them without their consent to an incurable sexually transmitted disease, an STD, or a venereal disease, genital herpes, an STD that he knew for years that he had and was being treated for. And as the government will prove during this trial, he was not able to do these things unchecked for multiple decades on his own without help. See, the defendant created this persona, R. Kelly, and he was at the center of it all. And he surrounded himself with people all at his disposal at his studios and on the road when he was on tour. People like his managers, his personal assistants, bodyguards, drivers, runners. Those are people who run errands and answer phones. lawyers, accountant, and even unpaid members of his inner circle. But he didn't just use these people to help him with his music career. No, he created and relied on his inner circle to facilitate and to help him cover up his crimes. For example, he directed members of his inner circle to approach young women and young men on his behalf when he wanted to meet them. The defendant had employees and associates give out his phone number to young people that he targeted. He instructed his assistants to book the travel of his victims, including minors, all over the country to see him. He used these drivers, bodyguards, assistants, and runners to keep watch over his victims and carry out the orders that he used to control them. And to try to ensure that his illegal conduct didn't ever see the light of day, he used his accountant and lawyers to pay hundreds of thousands of dollars of hush payments to people he thought might go public or go to the authorities. They did all these things, often without question, at the direction of the defendant. And as you'll hear, sometimes they did these things out of fear of him. Relying on his inner circle, the defendant engaged in criminal conduct over and over again throughout the country over the course of almost 30 years. And as time passed and the defendant committed these crimes without repercussion, his conduct became more and more egregious. He began collecting girls and women as if they were things, hoarding them like objects that he could use however he liked. He'd have them visit him, and eventually he'd have some of them stay with him at his home or at his studio or on the road with him in his tour bus or his Mercedes Sprinter van when he traveled for concerts, all so that he could have access to them for his sexual and other needs whenever he pleased. Now, the defendant maintained control over these victims using every trick in the Predator Handbook. First, he targeted minors and vulnerable young adults, picking them out himself or directed members of his inner circle to find them for him. He then got to work grooming them, which you will learn is when someone works to build a relationship of trust and emotional connection with a vulnerable person, like a minor, so that he can manipulate, exploit, and abuse them. In many cases, when the defendant first met them, he would even groom their family members, ingratiating himself with their family or their friends. Sometimes he promised to mentor their careers in the music or in the entertainment business. But then, after quickly reeling them in, he isolated these victims from their friends and family, convincing some of them to spend long stretches of time with him and even move in with him. And as soon as he had these girls and women under his thumb, he instituted a long list of rules that they were required to follow. Rules like he made them call him daddy. He told them never to speak or even to look at another man, but instead to keep their heads down if any other men were in the room. He instructed many of them to wear baggy clothing when they were not accompanying him to an event or unless he told them otherwise. He instructed that they needed to come to him before doing anything, causing them to spend hours on end waiting for the defendant to approve some of the most basic of requests. Requests like permission to leave to go to the bathroom and leading them to, in some cases, urinate in a cup rather than violate one of his rules. He required them to engage in sex at his direction with whomever and whenever he decided, and he recorded most of these sexual encounters. And above all else, he demanded absolute obedience. And if they didn't follow his rules, if they messed up in some way in his eyes, the defendant made sure that there were consequences. He exacted cruel and demeaning punishments. Sometimes he confined them to a room for days. He physically assaulted them, delivering violent spankings and beatings. And these rules, these punishments, they kept his victims compliant. But the defendant also did what he could to cover his tracks, just in case someone did actually decide to speak out or to, for example, go to the police as insurance, as a way to make sure that these girls and women felt that they could never, ever tell anyone about what he was doing. He created and kept collateral on them. He directed them to write letters containing false and sensitive information about themselves, or had them create embarrassing and degrading videos that he could lord over them if any of them crossed him. He photographed and filmed them naked and engaging in sex with him and others at his direction. And he kept this stash of sex videos and photos, not just for his own use, but always at the ready if he needed to protect himself by threatening their exposure. And if he couldn't use one of those methods to keep them quiet, he entered into secret settlement agreements, paying victims off so that his criminal conduct wouldn't become public. That's the man who sits here before you. That is how he, with the help of his inner circle, operated. I want to talk to you now about the experiences of 6 of the defendant's victims and tell you about some of the specific illegal acts that he committed with respect to these victims.
First, I want to tell you about Aaliyah. Aaliyah met the defendant in approximately 1992 when she was about 12 years old. Aaliyah has a gift. She was a talented singer and people thought that she could make it far in the industry. So the defendant began to produce and write music for Aaliyah when she was still a child. And shortly after he began working with her, the defendant began to engage in sexual activity with her. And for years, while Aaliyah was a minor, too young, apologies about this. And shortly after he began working with her, the defendant began to engage in sexual activity with her. And for years, while Aaliyah was a minor, too young to even consent to sex, he continued to engage in sexual activity with her that lasted several years. One night in 1994, while the defendant was on tour, he got some news about Aaliyah. She thought that she was pregnant. This, of course, was a huge problem for him. Why? Because at the time, Aaliyah was only 15 years old. And if she was pregnant, that meant that there would be questions, a lot of questions. At the very top of that list of questions would be, who is the father of the baby? So the defendant and his circle came up with a plan that the defendant thought would keep Aaliyah from talking, and a plan that would keep him out of jail if anyone found out. His plan, the defendant decided that he needed to marry Aaliyah. That way, as far as he understood, if anyone found out about the pregnancy, about his sexual activity with her, Aaliyah could not talk. In other words, if she's his wife, then she can't testify against him, or so he thought. Now, as I said, the defendant is on tour at the time and about to go on stage for a concert. In fact, he's got other appearance dates as part of this tour over the next few days, but he's got to get this done and fast. So he flew home to Chicago in the middle of the night with a few of his most trusted friends and employees. When they land, Aaliyah was waiting for the defendant at a hotel airport. Excuse me, at an airport near a hotel. And the defendant and his crew got to work. Aaliyah went to a hotel and they had a meeting there. and they got to work gathering what they needed to make this marriage happen. But there was a problem. Aaliyah was 15 and she needed an ID showing that she was over the age of 18. She needed that in order to get the marriage license. So the defendant and his tour manager decided to bribe someone that the manager knew at a local public assistance office who would give Aaliyah a fake ID that she could use to get the marriage license. And that's exactly what they did. The defendant, Aaliyah, and his tour manager drove to the public aid office. Aaliyah and the tour manager went inside. The tour manager paid one of the employees at the public aid office about $500, and they walked out with a fake ID for her, for Aaliyah. They made a few phone calls and lined up a minister to officiate the wedding. And in the hotel suite, the defendant, a 27-year-old man, married Aaliyah, a 15-year-old girl. And with that taken care of, the defendant flew back to where he had been to finish his concert tour.
Ms. Cruz Melendez, I am so sorry. I have to interrupt you. May I see counsel at the side with the court reporter for just a minute? Just one lawyer from each side is fine. Sorry about that. So this
goes in the category of things I don't know why I'm hearing about it. But apparently your witness wants to watch the opening statements.
Yes.
That would ordinarily be a thing that you should check with me before, because counsel may have some objections.
I definitely have objection to that, Your Honor.
It is not a good idea.
I apologize, Your Honor, but I spoke with Mr. Farinella last night and I advised him of this, and he indicated he did not have an objection to it.
May I have a word?
Sure.
Your Honor, it is my understanding that Mr. Farinella was under the impression, after speaking with the government, that the witnesses were entitled to be present for the opening. I told them that's not the case, and I believe we will object to it. So, I'm going to ask the witnesses now be precluded from continuing to hearing the opening remarks.
I don't think they're listening to it.
They're not? Okay.
No. Generally, we don't have witnesses in the courtroom for proceedings that don't involve them. I don't know that there is a blanket I don't know if there's a blanket prohibition against it, and it is certainly a subject for cross-examination, but it is just generally not done. If it is something that you're contemplating, you really should raise it with me.
I apologize.
So, there is an objection to it now. I'm quite confident that Mrs. Geddes was clear. I don't think that was a hypothetical suggestion. So,
I think it was misheard.
Misheard, that's exactly right. While I have you at the side, I'm also told that the guy who runs press at your office, I can't think of his name.
John Mezzarulli.
That he alerted all of the reporters that he will have exhibits in a Dropbox. It is probably fine, but this is not his show.
I understand.
So if anything like that is going to happen, obviously nobody can look. The press is entitled to look at the exhibits once they come in, but that's something that really should be done through the court. So I'm going to ask you to instruct him not to do that again.
Yes, I will. And there are plenty of exhibits we have an issue with. Just for the record, I want to just let everyone know that we found out late last night that this witness was insisting on attending the opening statements. And it's under the Crime Victim Right Act, which says that a victim witness, as opposed to another witness, has a right not to be excluded. Candidly, this is not the government's choice, and we understand the obvious examination avenue. But I think it is the government's position that under the act, she does, in fact, have the right to attend. But that's why we wanted to put everyone.
Is that an absolute right or discretionary? Does the court have discretion on it?
No, I think it's an absolute right.
I think it's an absolute right as well. I just wanted to one. I just wouldn't be. It wouldn't be normal for a normal witness, and we have advised every other witness who plans to testify that they cannot attend the proceedings, with the exception of our case agent, which is permitted under the law. But I think because she is a charged victim in the case, one of the rights protected under the act is the right not to be excluded. And my understanding under the law is that that includes even if she's a testifying witness.
She can attend if there is room for her in the overflow room. There are limited seats in there. So you can cross-examine her about her attending it. Again, in the future.
Yes, Your Honor.
Always good to know about these things ahead of time.
Which witness is this?
Number 5.
No, it's not. It's Geronda Pace. She's our first witness.
Oh, Geronda Pace. Thank you.
Okay. Okay. I apologize to Ms. Cruz Melendez. I apologize to the jury. I wouldn't do that if I didn't have to tend to some matter. So we're all set to go. Go ahead.
Thank you, Judge. Next, I want to tell you about Stephanie. When Stephanie was only 16 years old, she saw the defendant while she was at a local well-known McDonald's, known as the Rock and Roll McDonald's. She was there with her boyfriend and some high school friends when the defendant eyed her. When Stephanie went up to the counter, the defendant sent one of his associates over to her, who gave her a piece of paper with the defendant's telephone number written on it. And he told her that the defendant wanted Stephanie to call his. She told the associates that she was only 16 years old, and the defendant's associate said, "That's okay." Stephanie ultimately decided not to call the defendant, but about a year later, in 1999, when Stephanie was 17 years old, she heard that the defendant was making an appearance at a night store close to her summer job, where she was working as a barrister. She went to see him because she wanted to tell him about a friend of hers who was an aspiring singer. The defendant told Stephanie that he remembered her. She asked the defendant whether he would be willing to meet with her friend to hear her sing. The defendant agreed to see Stephanie's friend, but said he wanted to meet up with Stephanie first. And again, he gave Stephanie his telephone number. Stephanie was only 17 years old at the time. The defendant was 32. Just a week or two later, the defendant began having sex with Stephanie regularly for approximately 6 to 8 months. Stephanie's friend eventually did sing. Apologies. Sorry, she did sing for the defendant, at his studio, but he wasn't interested in that. What he was interested in, what he wanted, was to continue having sex with Stephanie. He'd have Stephanie come over to his studio to meet him, where she would wait in one of the rooms there for hours. And whenever he was ready, he would go into the room where there was writing and he'd have sex with her. Or he paid for her to travel out of the state to meet him so that she could have sex with him. He told her to call him Daddy and became controlling, directing her not to even speak or look at another man, making her afraid of the consequences if she did not do everything that he instructed her to do. On one occasion, while Stephanie was still a minor, the defendant told her he was picking her up from the studio where she had been waiting for him to bring her to his house to make a movie. Once they arrived, the defendant used a video camera to record a VHS tape of Stephanie having intercourse with him. Next, I want to talk to you about Sonia. Now, Sonia met the defendant outside of a mall in Salt Lake City, Utah, in 2003 when she was 22 years old. Sonia was an intern at a radio station and heard that the defendant was at the mall. So she headed over there with a friend, thinking that it would be great for her position as a radio station intern so that she could get an interview with the defendant while he was still in town. When she got there, the defendant didn't give her an interview, but he or one of his associates did slip Sonia the defendant's number, still hoping to land the interview with the defendant. Sonia called the number to see if she could set up a meeting with him. After some time and several calls later, the defendant invited Sonia to his studio in Chicago. One of the defendant's employees arranged her travel, and she flew to Chicago to meet with the defendant in the hopes of getting that interview. When she arrived at the studio, it was nothing like she expected. One of the defendant's employees asked her if she needed condoms. Taken aback by the question, she said no, that she wasn't there for anything like that. One of the defendant's employees then escorted her to a small room, went through her luggage and phone, made copies of her ID, told her to sign a non-disclosure agreement, and left. Alone in the room, and soon discovered that the door was locked. And despite her knocks on the door and calls to the front desk, no one let her out to leave. Sonia spent approximately 3 days in that room, pleading to be let out, to go home, to get some food, to be able to go to the bathroom. But when she heard from defendants, the various employees, that were enforcing his instructions, was that they needed authorization from the defendant first to let her leave the room. The few times that she was actually allowed to leave the room to use the bathroom, she was generally escorted by one of the defendant's employees. Days went by, and finally, one of the defendant's employees bought Sonia some cold Chinese food and a Coke. After taking a few bites and drinking the soda, her eyes grew heavy and she fell immediately to sleep. Sonia woke up to find her underwear had been taken off and felt a wetness between her legs that made it clear to her that she had been sexually abused in some way while she was not conscious. She also saw the defendant in the corner of the room, doing up his pants. Confused, She stood up to speak with him. He grabbed her backside, pulled her towards him, and said he had to go. Then he left. That was the first and only time Sonia saw the defendant on that trip. Only then did one of the defendant's employees come and say that they would let her leave, but not before telling her that she could never speak about what happened there to anyone, and taking a list of people, including the grandmother's name, who were close to her. All of this she took as a terrifying threat. Keep quiet, or else. And it worked. She did keep quiet for almost 16 years. Now, I want to tell you about Joanda. Joanda first met with the defendant in 2009 when she was only 16 years old at a party at the defendant's house. In 2009, the defendant was 42. Excuse me. Joanda was a huge fan of the defendant's music, and when she met him at the party, she naturally was excited to be talking to him. And while they were talking, she told the defendant that she was 19, which wasn't true. On the night, she and the defendant exchanged phone numbers, and just a few days later, the defendant invited Joanda over to his house. And when she got there, after some conversation, she told him that she was a virgin. He told her that he wanted to train her, to teach her how to give oral sex, and that's how it started, with oral sex. Soon after, the defendant and Joanda had sexual intercourse. Now, shortly after the defendant began having sex with Joanda, Joanda told the defendant her true age. She told him that she was actually 16 years old. She even showed him her ID card. She told him that she was actually 16 years old. And what did the defendant do? He didn't ask her to leave. He didn't say, "We can't see each other because you're a minor, because you're 16 years old." He shrugged it off. He asked her, "What's that supposed to mean?" and instructed her to just continue to tell people that she was 18, 19. And for the next 6 months or so, the defendant continued to have sex with Joanda, a 16-year-old girl, too young to consent to sex regularly, for the better part of a year. At times, he video recorded sex with Joanda using a video camera or an iPhone. The defendant also became controlling, making her follow a list of rules, and he became violent with her. At one point, the defendant even instructed Joanda to write and sign a letter that he could keep an insurance policy of sorts containing false information saying that she worked for him, that she had stolen money and jewelry from him, and that her parents told her to get close to the defendant. On one occasion, one of the several times that the defendant became angry with Joanda, he slapped her, choked her, and threatened that the next time it would be even worse. And then the defendant, while Joanda was shaken and upset from the beating, made her give him oral sex. That was the last day that Joanda was with the defendant. I'd like to talk to you now about Zell. Zell first met the defendant when she was 17 years old in 2015. He was 48. She had gone to one of the defendant's concerts with her mum and dad, and during the show, one of the defendant's associates gave her a wristband so she could come up and stand near the front of the stage. During the show, the defendant paid extra attention to her, singing some songs directly at her, and then one of his associates gave her his number and told her not to say anything to anyone. After the concert, Zell began to communicate with the defendant. Now, Zell initially told the defendant that she was 18. She was a serious singer, performing in choirs and even doing some paid gigs. She thought maybe the defendant could help her with her career. The defendant told Zell that she should have come and audition for him, thinking that this could be her big opportunity. Zell headed to meet the defendant one day after her high school extracurriculars. He told her to swing by the hotel where he was staying. So she met him on his Mercedes Sprinter van that was parked outside the hotel. Once there, he asked her to sit on his lap and give him a kiss. She was unsure, but she did what he asked. The defendant then asked her to meet him upstairs in the hotel room. She did. When they were alone in the room, Zell asked if it was time for an audition. The defendant told her before he could hear her sing, he needed to relieve himself. It was clear what he meant. He wanted to relieve himself sexually. Not wanting to do anything with the defendant, Zell tried to politely decline. None of it fazed him. He continued to hound her for some form of sex, telling her that he wanted to perform oral sex on her, and that if she let him, he'll take care of her for the rest of her life. Finally, reluctantly, she let him. Eventually, she got to sing for the defendant. After that, the defendant spoke with Zell and he invited her to travel to various shows around the country where he was performing, or to visit him at his home in Chicago, directing members of his inner circle to arrange travel for her. During these trips, the defendant continued to engage in sex, with her video recording the sex most of the time. Still, the defendant talked to her parents about how important it was for Zell to practice and learn the business, and telling them that he could help her with her career. And under the guise of mentoring her, telling Zell that she was going to be the next Aaliyah, he invited her to travel with him while he was on tour, all the while continuing to have sex with her. After spending all summer with the defendant on tour, when the time came for Zell to start her senior year in high school, she told him that she was, in fact, 17 years old. Did he end it? No. He suggested she do her senior year remotely and live with him full time. He continued to have sex with her in various locations around the country, despite the fact that she was a minor and too young to consent to sex. And the defendant not only had sex with Zell when she was a minor, but he also exposed her to an STD, genital herpes. Years earlier, the defendant was diagnosed by his doctor with herpes, an incurable STD. His doctor told him that he had the disease and that he needed to disclose that fact to his sexual partners and to practice safe sex. But the defendant never told Zell that he had herpes. As you will learn during the trial, ladies and gentlemen, this is a crime in both New York and California, two of the places that the defendant had sex with Zell. And as you will hear, as you will learn, herpes is an incurable disease that can cause serious and permanent bodily injury. And if you know you have it, and the defendant was well aware that he did, the law requires that you disclose the fact to your sexual partners so that they can consent to having sex under those circumstances, but the defendant never did. Over the next 5 years, Zell travelled and lived with the defendant, and throughout the defendant sexually, physically, and psychologically abused Zell. As with the other girls before her and after her, the defendant subjected Zell to his strict rules, instructing her to call him daddy and prohibiting her from doing even the most basic of things without his authorization. And as he did with other girls and women he targeted, he punished her severely when she broke his rules, giving her violent beatings that he called chastisements, to teach her how to behave and how to follow his rules. For some time, these chastisements happened every day. Sometimes the defendant forced her to have sex with a man that she never met before as punishment for breaking one of these rules. On multiple occasions, he confined her to her room for days without letting her leave. I'd like now to talk to you about Faith. Faith met the defendant in 2017 backstage after one of the defendant's concerts in San Antonio, Texas. Faith was 19. The defendant was 50. Two of the defendant's associates approached Faith after the concert and gave her and her half-sister wristbands to go backstage for a meet and greet after party. When Faith got backstage, there was a party of about 30 people, and everyone at the party, except for the defendant's employees, were women. After watching her dance, the defendant approached Faith, handed her his number, told her to take it, but not to tell anyone that he had given it to her. Faith called the number and the defendant, and she began communicating. Within a week, the defendant told Faith that he loved her, invited her to come see him, and told her that she could contact one of his employees to make her travel arrangements.
Now, eventually, at the defendant's invitation and completely on his dime, Faith began traveling to various locations around the country to see the defendant, and he began a sexual relationship with her, sometimes recording the sexual activity on his iPad. On one of these occasions, when the defendant had one of his employees arrange travel for Faith to come and see him, the defendant brought Faith into a small room and he told her to take off her clothes. In the room, in her view, right by the defendant, was a gun, which the defendant placed nearby. He then began to ask her a series of questions and told her that there would be consequences if she lied. Scared by the situation, believing that she could not leave even if she wanted to, Faith did what the defendant asked her to do, including when he directed her to give him oral sex. Now, when she traveled to see the defendant, including in New York As was his practice, he engaged in unprotected sexual intercourse with her, never disclosing the fact that he had previously been diagnosed with herpes. And when Faith sued him for exposing her to herpes, the defendant and others on his behalf threatened to expose compromising photos and videos of her that he had in his possession if she didn't cease her lawsuit or stop speaking publicly about the defendant. For all of this conduct, the defendant is charged in a federal indictment with multiple crimes.
First, he is charged with racketeering. You're going to learn some more detail about what racketeering is at a later point in the trial from Judge Donnelly. But what it essentially means is that the defendant is charged with committing a pattern of multiple crimes spanning almost 3 decades as the leader of an enterprise. An enterprise which you will learn more about as well as another word for a group of people working together to carry out a certain purpose. Here, the defendant and his inner circle, together with the defendant at the centre of all of it, they formed the charged enterprise. The racketeering activity that the defendant is having charged with committed by using his inner circle includes conduct related to the 6 victims I told you about earlier. When I described to you some of the experiences of the 6 victims, I explained that some of the victims, like Aaliyah, Stephanie, Joanda, and Zell, were minors when the defendant began having sex with them. The charged racketeering activity related to those victims included bribery, sexual exploitation of children by producing child pornography, forced labour and illegal transportation, coercion and enticement of minors for the purpose of engaging in illegal sexual activity, including sex with minors, and illegally failing to disclose his herpes to his sex partner before having unprotected sexual intercourse.
Some of the other victims, like Sonia and Faith, were over the age of 18. The charged racketeering activity related to them includes kidnapping, forced labor, and illegal transportation, coercion, and enticement of these individuals for the purpose of engaging in illegal sexual activity, including aggravated sexual abuse and illegally failing to disclose his herpes to a sexual partner before having unprotected sexual intercourse. The defendant is also charged with 8 other separate crimes related to the defendant's transportation, coercion, and enticement of Zell for the purpose of engaging in sex with her while she was a minor, as well as transportation, coercion, and enticement of Faith to engage in unprotected sexual intercourse with her without first disclosing to her that he had contracted herpes.
Now, during the course of the trial over the next few weeks, the government's going to present evidence to you that will prove these charges beyond a reasonable doubt. So how will we prove these charges to you? What is the evidence? First, you're going to hear from many of the defendant's victims themselves, who will tell you the many different ways the defendant exploited them. You will also hear testimony from various former members and associates of the defendant's inner circle, people who work for the defendant, such as his personal assistants, managers, and runners, as well as people who were his close associates going back all the way to the 1990s and as recent as 2018. People who the defendant used to facilitate his crimes, for example, by directing them to arrange travel for them, for his victims, throughout the United States, including right here in the Eastern District of New York, and using them to enforce the defendant's instructions that he used to control almost every move of his victims. You're also going to hear from expert witnesses, including a clinical and forensic psychologist. She will testify about the methods used by predators to target and groom vulnerable people like minors and young men and women. She will also testify about the effects of violence in relationships and the associated trauma with those relationships.
She will also testify about the effects of violence in relationships and the associated trauma with those relationships. She'll explain why victims often stay with their abusers and delay reporting acts of abuse and violence to law enforcement. You will also hear from experts who will tell you that the defendant's DNA was found in semen recovered from a t-shirt by one of the victims when she was just 16 years old. All right. In addition, you will see evidence, or you will hear evidence such as official documents like birth certificates for the victims and the documents proving that the defendant did marry Aaliyah when she was just 15 years old. Text messages showing that the defendant demanded total obedience, that he had members of his inner circle staying guard over his victims when they were on punishment. Telephone records showing contact between the defendant and his victims, including while they were minors. You're going to see travel records that show the victims traveling to locations around the country to see the defendant. Medical and prescription records regarding his treatment for the disease that will be explained during the testimony of the defendant's primary care physician regarding the defendant's herpes diagnosis. You're also going to see physical evidence obtained by law enforcement from searches done pursuant to search warrants authorized by a judge, the defendant's own apartment and storage facility. For example, you'll see decades-old paper phone messages recording calls from his victims. You'll see video and audio recordings that the defendant made himself or instructed victims to make that show the type of control that the defendant had over his victims and the demeaning punishment he forced them to perform if they broke his rules. Some of these recordings may be difficult to listen to and to watch, but we will be presenting this evidence to you to prove the defendant's pattern of illegal sexual, physical, and psychological abuse. You're also going to see letters the defendant kept containing false and embarrassing information, which the defendant directed his victims and others to write so that he could have them in his back pocket in case anyone attempted to accuse him of wrongdoing. You will see records such as settlement agreements showing that the defendant tried to pay millions of dollars to keep his victim silent. Witness after witness, exhibit after exhibit. You'll have the chance to hear and see all the government's evidence. Now, because of the nature of the trial, some of the evidence may be presented to you in a way that's not always in complete chronological order. But by the end of the presentation of evidence, you will see how all the government's evidence fits together to prove each and every one of the charges in this case. And after we presented all of this evidence to you, after you heard from the witnesses and seen all the exhibits, the government is going to have an opportunity to come before you again and review all of that evidence with you. And at that time, we're going to ask you to hold the defendant accountable for years of engaging in sex with minors creating child pornography, and otherwise sexually abusing girls, boys, and young women. Accountable for using bribery, lies, fear, and extortionate tactics to keep his victims and other potential witnesses silent. We will ask you to reach the only verdict that is consistent with all of that evidence, and that is a verdict of guilty on all counts. Thank you.
Thank you, Ms. Cruz Melendez. Does the defendant wish to give an opening statement?
Can we have a break?
Surely. We'll have a break for about 10 minutes. Please don't talk about the case at all, and we'll see you in just a few minutes. Thank you so much.
All right.
Okay, anything before we break, just with respect to I think we can, just to expand on what happened at the sidebar. There was a request that one of the victims be permitted to view the opening statements, which is permissible under the Crime Victims Act, also as enacted by Federal Rule of Criminal Procedure 60. The government represented that Mr. Farinella consented to this last night, but ordinarily, which is why I didn't rule on it before, but if this is going to happen, it's usually good to bring it to my attention. All right? Thank you so much.
All rise.
Everyone can have a seat. All right, are we ready for the jurors?
Yes, Your Honor.
All right.
All rise. You may be seated.
All right, jurors, we're ready to continue. I do want to say, I think I've told you this before. I know it's cold in here. It's either really hot or really cold. And believe me, it's much better when it's cooler. But it's probably not a bad idea to bring a sweater with you or something. So I truly am sorry about that, but it's the way it is. All right, we're ready to proceed with opening statements. Does the defense wish to give an opening?
Yes, Judge. Thank you.
Go ahead.
Thank you. Sorry, ladies and gentlemen. We don't learn in law school how to put these microphones on. Good morning, ladies and gentlemen.
Good morning.
Ladies and gentlemen, my name is Attorney Nicole Blank Becker, and I am one of the 4 attorneys who are here today defending our client. Ladies and gentlemen, I want to introduce to you who is sitting at the table. We got Attorney Tom Farinella, who, ladies and gentlemen, has been working as a lawyer for over 20 years here in New York, federally and statewide. Additionally, we have Deverix Canick, a long veteran of both state and federal court, who started as a prosecutor.
I'm so sorry. Can I see the lawyers at the side, please? So you can't make those kind of remarks in opening statement. You're supposed to talk about what you expect the evidence to prove and not talking about everybody's background as lawyers. It's just not appropriate. But you can certainly talk about what you think the evidence is going to prove, but let's not have any more bios, okay?
Okay. You remember when the prosecutor did her opening, she described what she does and who she is.
No, she did not. She said she was an assistant United States attorney. You've already said you're a lawyer, but we don't do resumes in an opening statement. So what I like you to do, I don't like to interrupt lawyers doing opening statement, but that's just improper. So let's go ahead.
May I, Judge?
Yes, go ahead.
Thank you. Lastly, ladies and gentlemen, I don't want to leave out Calvin Scholar, who is with us as well. Ladies and gentlemen, I suggest you that the fundamental reason that we are all here today is because the government wants you to believe our client an internationally known singer, someone that they want to believe is the leader of some large enterprise, similar to John Gotti, the head of a mob family. Ladies and gentlemen, by charging Mr. Kelly, an internationally known singer, as the leader of an enterprise, the evidence will show that this is uncharted territory. You're not going to hear any evidence of anybody who comes in here and tells you about their experience with these kinds of charges. Ladies and gentlemen, I'm going to ask that throughout this trial, my team is going to ask that you listen carefully to how the government puts on their case. In an attempt to paint Mr. Kelly, our client, who sits at the defense table, out to be some singing boss, it will be clear that the government will not be able to prove their case beyond a reasonable doubt. And here is why. What the government wants you to believe and stood up here and will ask questions about throughout this trial. The government is going to tell you that Mr. Kelly himself is being charged with what is known as a RICO statute. RICO, ladies and gentlemen, a statute that is and was used and founded for organized crime that the government is also charging Mr. Kelly with. Something that you will learn is called the Mann Act. Again, a 110-year-old charge.
Objection.
Sustained.
Ladies and gentlemen, I want to explain to you and break it down what the defense believes the evidence is going to show. And I'm going to break it down by who, so that 1 + 1 = 2. Making it that easy for you, because I know, our team knows, the words like enterprise, trafficking, transportation over state lines. Those sounds like some pretty serious charges. Let me show you how the government is going to have a difficulty proving their case. Ladies and gentlemen, the evidence is going to show that the government wants you to think that Mr. Kelly single-handedly directed a very elaborate scheme, a scheme that was all hidden behind RKelly the singer. Ladies and gentlemen, the whole purpose, they will tell you, of promoting Mr. Kelly music for years and years and years was designed to recruit women and girls, fly them from state to state, country to country, all for one purpose, so he could have illegal sexual activities with them. Ladies and gentlemen, you will see for yourself, not just me standing before you and telling you that the idea and notion that individuals are going to get on the stand. They are going to tell you enough. They are going to tell you enough concrete evidence that Mr. Kelly is part of this huge collaborative. I suggest to you, it's not going to happen. Ladies and gentlemen, we believe that you're going to hear about several gaps in the government's case. Specifically, part of what they have to prove to you is that there was a continuous ongoing enterprise. Ladies and gentlemen, I suggest to you that you are not going to hear from one person on that witness stand who is going to say, I've been with Mr. Kelly for 30 years, almost as long as he's been singing. Why is that important? Ladies and gentlemen, why do I care to stand here and tell you about that? Well, ladies and gentlemen, that's part of what they must prove to you beyond a reasonable doubt, a continuous and ongoing enterprise. Additionally, ladies and gentlemen, you're also going to hear this case starts with allegations from 1993. Well, ladies and gentlemen, you're going to hear from that witness stand that Mr. Kelly, although he had begun singing in the early 90s, he stopped his career. He actually played professional basketball. And And you'll hear individuals on the stand tell you that from 1995 to 1997, 1997 to 1999, he wasn't singing at all. He wasn't allowed to sing when he was doing his professional basketball. And why is this important? Again, must be ongoing, continuous, can't have something happen here in the 90s. Let's wait 5 years, 10 years, 20 years and call it an enterprise. That's not what the law will tell you. Those are details, ladies and gentlemen, that you may pay attention to. The details in this case, we anticipate, are going to make you think to yourself, is there something else? Did I miss something? But, ladies and gentlemen, if you don't believe this element, this part that we're talking about right now, the fact that there was some ongoing and continuing enterprise, then, ladies and gentlemen, you have to be the ones to stand up, raise your hand in that jury room and say, I didn't hear that, or I'm following the law. And the law doesn't say that. The evidence that you're going to hear throughout this trial, we believe, will make it nearly impossible for the government to prove their case beyond a reasonable doubt. We believe that the witness that take the stand, they will not hold up to scrutiny. In fact, we believe their testimony will crumble when it comes to cross-examination. We suggest that there will be so many untruths told to you, ladies and gentlemen, that even the government won't be able to untangle the mess of lies. Remember, ladies and gentlemen, that each witness who comes into this courtroom and who takes the stand swears to tell the truth. You, ladies and gentlemen, ultimately get to be the only ones determining if you believe that they are actually the truth. If you decide that you don't believe everything or even just part of what a witness says, you have the ability, and the law and your honor will tell you, you as jurors have the power to decide who you believe, what you believe, and how much you want to believe. As sworn jurors on this case, you have one of the most awesome responsibilities. And when you listen to both the direct, which is when the government asks questions, and the cross examination by the defense, you will wonder, where is the proof? Where is the proof beyond a reasonable doubt? Now, the government, they will, we anticipate, parade witnesses after witnesses after witnesses to that witness stand. And they will attempt, we believe they will attempt to put a square peg into a round table. Ladies and gentlemen, as they do that, you will use your common sense, and it will be obvious that what's happening, you will ultimately come up with the conclusion as you watch the witnesses after witnesses come forward, untruth after untruth, after a little bit of truth, and more untruths, that if the government isn't able to fit all of their witnesses into this round hole, it will be obvious that these charges are overreaching. While the government will showcase basically every witness as they come up, you'll get to hear from them yourself. Don't assume that everybody is telling the truth. I know that sounds like something that is obvious, but ladies and gentlemen, remember, when people talk, when people testify, you don't leave your common sense at the door. No, ladies and gentlemen, you come in the courtroom and you swear to tell the truth. And I hope that you hold them to that. Now, no matter how many witnesses the government may call, and I suggest, and we anticipate, it may be a number, a lot, just because someone has 5, 15, 20 witnesses that take the stand, the law is actually, and the court will tell you, that you don't judge guilt or innocent based on number of people that take the stand. You base it on the number of people that testimony that you believe. Ladies and gentlemen, we suggest that you are going to hear a number of half-truths, exaggerated testimony. And we also suggest that the witnesses that you're going to hear from have an agenda. An agenda. Ladies and gentlemen, I don't just pick that out of the air. You're going to hear that some of the witnesses, they wrote a book. A number of them wrote books. You're going to hear some of the witnesses will get cash from Mr. Kelly to pay for their families' bills or issues that were going on with them at home. You're going to hear some of the witnesses went on elaborate shopping sprees, and some enjoy the notoriety of being able to tell their friends that they were with a superstar. Frankly, ladies and gentlemen, what we believe the evidence is going to show is that these women, these witnesses who take the stand, he didn't recruit them. Ladies and gentlemen, you will hear that they were fans, that they came to Mr. Kelly. Now, did he pay for an airplane ticket? Yes, he did. Would he pay for a hotel or an Uber? Yes, he did. But ladies and gentlemen, does that mean that he was running a monumental enterprise? No. You won't see that or hear that when the judge tells you about the law. These witnesses, each one of them, specifically Jane Doe's, you will see that they had both a personal and financial basis to be in a different relationship with Mr. Kelly. Now, the defendant will paint a picture. Now the government will paint a picture and the witness will take the stand and tell you all these negative things. In fact, they're going to form a picture that basically Mr. Kelly is this monster. Ladies and gentlemen, you are also going to hear that some of these relationships that Mr. Kelly had, they were beautiful. He actually had, which no one is talking about, long-term relationships with many of the Jane Does and individuals who take the stand. And the evidence is also going to show that these witnesses, they knew exactly what they were getting into. What do I mean by that? Ladies and gentlemen, it was no secret that Mr. Kelly had multiple girlfriends. Everybody, the witness that you'll hear from, they knew about that. It's no surprise. And ladies and gentlemen, you even know that Mr. Kelly was quite transparent. And he would tell the witnesses, the Jane Does, those he was intimate with, that there were other women that he was dating as well. From a man who you will hear has a very, very busy schedule. He had relationships that he tried to cultivate. How to how how do you cultivate a relationship with a woman, or the government wants you to say a man? You bring them into wherever you're working because you don't have one place. He doesn't have just one house, one office. No, ladies and gentlemen, he is on the road. You will hear most of the year when he's doing a tour. If he wants to see, or you'll hear, they want to, they want to come see Mr. Kelly. It makes sense. They hop on a plane and get to see him. Ladies and gentlemen, you'll hear that Mr. Kelly was married before. Not only was he married, he is the father of 3 children with his ex-wife. Ladies and gentlemen, it's not a secret that he wasn't trying to get married again. He wasn't trying to get married again. And each individual who came into his life was made aware of that. We believe that you will hear that the relationships that Mr. Kelly had with the various Jane Does were consenting relationships. These were individuals who knew what they were getting into. And I don't mean, you may be thinking to yourself, well, you're going to hear that they were getting into some, as the government suggested, horrible types of relationships with Mr. Kelly. No, you will hear that the Jane Does, most of them, they contacted Mr. Kelly. Sure, did they contact him because they received his phone number? Yes. How else in the 90s and coming up into the 2000s do people contact each other? So the fact that these individuals who wanted to be in Mr. Kelly's life, whether or not we understand their reasoning or we agree with the reasoning, this is not a situation, and you will not hear that they were recruited. If by recruited, the government wants you to believe that that means that Mr. Kelly had an assistant who was responsible for keeping his daily routine up to par and on time. As the assistant was the one who is, I'm sorry. And the assistant was the one who, if Mr. Kelly and or you're going to see the witnesses spoke with the assistant. If they wanted to come, or depending on what date, not only work for Mr. Kelly, but you'll see that worked for the individual coming to see Mr. Kelly. Yes, they dealt with one of his assistants. The government will have you believe that the assistant was part of this large enterprise. Ladies and gentlemen, I suggest that you will hear from one of his assistants, if not more, and you will hear what her role was, her job as an employee, and it will be nothing more and nothing less than anyone else that was standing in her shoes. It was for the purpose of being an assistant. Now, ladies and gentlemen, we've discussed how you're going to hear about a number of consensual relationships with adults. You're going to hear about how those relationships oftentimes ended. You will hear that when a relationship, not all, but when a relationship ended and it soured, those individuals become angry, resentful, and even spiteful. And that's when the evidence will show, and you will be able to see that when they take advantage of their situation. We anticipate, ladies and gentlemen, that some of the witnesses that were going to take the stand, they were going to tell you, they are going to admit that they have stolen money from Mr. Kelly. They are also going to tell you that when they were in a relationship with Mr. Kelly, they had cheated on Mr. Kelly. These aren't things that you're going to hear are made up. They will tell you this themselves. You're also going to hear they are going to tell you they bold-faced lied to Mr. Kelly. Now, the other part that you're going to hear, that there were a number of relationships in which Mr. Kelly and the individual broke up, and it was amicable. They are still friends. They form lifelong relationships, but nobody wants to talk about that. The evidence is also going to show you that there was a clear, distinct difference between Mr. Kelly and his personal life, as we all have, and RKelly and his business life. Now, you're going to hear that Mr. Kelly had a persona, is what they called it. We know that he goes by the name of RKelly. Why? Ladies and gentlemen, he's a singer. He is not the first and will not be the last person to do so. Now, you're going to hear that he had these relationships that he had nothing to do with RKelly, the singer on stage. What do I mean by that? Why I am talking about that? Well, ladies and gentlemen, you're going to hear that the witnesses, that the individuals who testify, the Jane Does, they rarely, if ever, had anything to do with RKelly on stage. Did they go to the concerts? Did they travel with Mr. Kelly? Sure. In fact, I keep saying they. I should explain that to you. Ladies and gentlemen, remember earlier I told you that you will hear that they knew about each other. You'll hear that they didn't just know about each other, they all became like a family. Sure, we're some women not so interested in being in those kind of situations. Yes, and they have a right to be. You'll hear, ladies and gentlemen, that they ended their relationship because that's not what they wanted to sign up for. But you will also hear that the Jane Does and or other women in Mr. Kelly's life that the government is going to put on the stand. They were part of his personal life. His personal life, if you notice on the charges, is not on trial here. His personal life is separate. He is not being charged individually. The charges are grandiose. He can't be the leader of his own enterprise, and the enterprise is not how it works.
I'm going to caution the jury. I'll instruct you on the law at the appropriate time. Go ahead, Ms. Becker.
Thank you, Judge. You're going to hear that the witnesses in this case, they will take the stand, and they're going to tell you all about their experience, their personal experience with Mr. Kelly. I suggest to you, ladies and gentlemen, we believe the evidence is going to show that they had relationships just like anyone else. In fact, ladies and gentlemen, just because the girls, women, excuse me, the witnesses, the Jane Does that he dated, just because they came to the concerts with him, they sat in the audience and will watch and support. It doesn't mean they are a part of the show. Just as much, ladies and gentlemen, as my family isn't part of me being a lawyer, there is a clear distinction, and that distinction is important. When Your Honor tells you the law, you will see how important it really is. Now, if the government is not able to prove to you that Mr. Kelly's personal life and his business life are not interchanged, excuse me, yes, that they are not interchanged, they are two separate things. Guess what? Fails.
Again, Ms. Becker, I will instruct the jury on the law. Please confine yourself to arguing what you expect the evidence to prove.
Thank you, Judge. We expect the ladies and gentlemen that the witness will take the stand. They will look at you in the eye. They will swear that they are telling the truth. In fact, they are going to tell you they are victimized. They are going to tell you about a number of horrible sounding things that they experienced while with Mr. Kelly. In fact, they are going to allege that he would take their phones and they wouldn't have a phone to call anyone. They're going to allege that they were starved and they couldn't eat unless they were told they could. You're going to hear that they were locked in rooms and secret places and that they weren't permitted to leave the room without permission. You're going to hear that they weren't allowed to even look at other people, let alone other men. And you're going to hear that they were made to urinate in cups or buckets. Ladies and gentlemen, you will see and you will hear that all of these stories, all of their explanations are going to sound kind of similar. Now, they are going to use the same buzzwords, and you may, as you listen to that, think to yourself, well, whoa, it must have really happened if they are all saying similar things. But ladies and gentlemen, remember, when you were asked questions initially, when you were trying to find a jury about the media, about TV, anything about it, well, ladies and gentlemen, I suggest to you that those who take the stand, they are going to tell you they have seen, read, or even personally been involved in all that stuff. that they were asking you guys about. And why is that important? Why am I bringing that up? Because, ladies and gentlemen, that all makes using those words, buzzwords, like I couldn't eat. It was a cult. Those buzzwords, they are amazing in the media. They are amazing on a TV show. That some of these witnesses will tell you talk shows that they went on. That is audience grabbing. Ladies and gentlemen, as we all know, they must come in here and testify in the courtroom, no matter what they heard or saw. This is a courtroom where they must tell the truth. Watch as this unfolds. Ladies and gentlemen, you are also going to hear that Mr. Kelly had rules that they must follow. The sound of that alone is pretty daunting. Rules in a relationship. Ladies and gentlemen, when the ladies, the Jane Does, take the stand, or the witnesses, and they tell you about the rules, here is another place to pay special attention to. Listen to how fantastical they tell you the rules are. Ladies and gentlemen, we suggest that they are Monday morning quarterbacking. What do we mean by that? Ladies and gentlemen, we suggest you'll see and you'll hear from the stand that when things didn't get to be the way they wanted it, I don't know, maybe they wanted the relationship to continue and it couldn't. Ladies and gentlemen, when the witnesses were in a relationship with Mr. Kelly that worked, nobody would testify. They complained about some rules. But guess what? When that relationship, that sexual relationship ended, now what? All the private conversations, the private understandings that they would have with someone they are dating and sexual active with, it's time to start talking to the public about it. And when you tell someone that you had to wear baggy clothes, you're going to get someone's attention. But ladies and gentlemen, what you also have to listen to is what we call the totality of circumstances. What do I mean by that? Ladies and gentlemen, you're going to hear, yes, a lot of girls ending up wearing baggy clothes, but not because it was a rule. You'll hear, ladies and gentlemen, that concerts that Mr. Kelly would put on had thousands, if not tens of thousands of people that would go to them. And ladies and gentlemen, you will hear the witnesses will tell you that it wasn't always so fun to be ushered amongst the crowd to get into the seats so they would watch their man at his craft. In fact, ladies and gentlemen, you're going to hear that that was becoming a problem for the women. And so, ladies and gentlemen, in order for them not to have to feel like they are being looked at or watched or poked at, they wore baggy clothing. But because we're here for charges of a RICO, we have got to make the narrative different. And the narrative that comes from that stand and going to almost making everything seem shady. Ladies and gentlemen, throughout this trial, we're going to ask that you ignore what we're going to call the window dressing. You're going to hear so much drama from that stand. In fact, so much drama it will almost take you off your path. But ladies and gentlemen, if you stick to your goal, if you stick to what you're here for, and you apply the laws as the court would give you, the drama would dissipate, the truth will be clear. You're going to hear from the witnesses that they hopped on planes, that they drove their car to go see Mr. Kelly, that they checked in on their own to hotels and got themselves Ubers, all while claiming they were held in some secret room and couldn't get help. Ladies and gentlemen, that's the kind of drama that we hope after hearing each witness or while listening to them, you're able to put aside. We suggest to you that you're going to hear that the girls, the witnesses, they will go out, they will get their hair done, they will get their nails done, they will go shopping without Mr. Kelly. And guess what? They will have with them when they would go do it. Wait a minute. They will have with them when they would do it a cell phone, a cell phone that could essentially rescue them if that's the position they were really in. I want to address another thing, another drama that you're going to hear about. And that's one of the rules where they had no go to the bathroom in a bucket or a cup. That they weren't allowed to use the bathroom. Ladies and gentlemen, you will hear from the stand that a number of the witnesses went with Mr. Kelly on long tours. And you're going to hear also, ladies and gentlemen, that because Mr. Kelly is scared to fly, the tour bus was the main transportation. Not only did he have a tour bus, but you'll also hear about a sprinter van that traveled from location to location as well. And yes, ladies and gentlemen, you will hear that there were times when they are on one of their long tour drives in the cities they weren't familiar with, and did someone in the sprinter van that doesn't have a bathroom pee in a cup. Yes, you might hear that. It's not illegal, though. Ladies and gentlemen, wait until you hear the law. It's not as nefarious, ladies and gentlemen, as the government would like you to believe. The tour bus you will hear, the tour bus had a bathroom. So that part, when they testify about that, or if it or if they testify about that, ladies and gentlemen, that doesn't make any sense. There will also be testimony that Mr. Kelly had employed what are called runners. Runners, which is a common term you'll learn in the music industry. Runners, basically, you will hear, they did what everybody else didn't want to do. They are irrelevant to the interns. I'm sorry, they are irrelevant to the interns. They didn't get paid. Some of them did. Ladies and gentlemen, you will hear that one of those roles of a runner included being at the receptionist desk, including ordering food, any guests at the studios needed. They also had to clean the studios. And yes, when they would clean the studios and they had to do the nitty gritty work, a studio that you'll hear had enormous amount of people in and out and in and out. Then yes, a runner or two will take that stand and tell you that they recall when they were cleaning one of the buckets or the cups that they had to throw out or get rid of smelled like urine. Now, ladies and gentlemen, does that sound like the rules that you're going to hear by the women on the stand about not being able to go to the bathroom and having to pee in a cup? Or does that sound like what may happen in your vehicle when you drive a long-term vacation? Now, you are also going to hear, ladies and gentlemen, that Mr. Kelly, he lived and has been living what some may call extraordinary life. You will hear that he has sold millions upon millions of records. You will hear that he was number one in his craft. In fact, you're going to hear that he has so many fans that truly love and adore him. Ladies and gentlemen, you're going to hear that he had music and wrote music for true that truly touched and uplifted people's lives.
Objection.
Sustained. Sustained.
Now, ladies and gentlemen, Those are, thank you, those are blessings, ladies and gentlemen, that you will hear.
Sustained. I sustain the objection to that. Move on to something else, please.
When Mr. Kelly grew up, which is something you're going to hear about, and ladies and gentlemen, you are going to hear the court tell you that sympathy, feeling bad for someone cannot play a role at all in your deliberations. But when you hear and you will about how Mr. Kelly worked his way to being who he is, the discipline that Mr. Kelly was involved in, ladies and gentlemen, that's what we're talking about when I say the totality of the circumstances. Mr. Kelly, you were here, started on the streets of Chicago.
Could I see the lawyers at the side, please, with the court reporter?
Can someone fill in for me? Right, take a bathroom break, please.
Yeah, I can.
What's your objection?
My objection is I don't know how this has any relevance whatsoever to the case, nor how it's coming in.
Well, I am curious about that. Is he going to testify? That's the only way that will come in.
No, they have a witness, Demetrius Smith, that is going to testify about this stuff. And specifically, the reason we're even going back to 1993 is due to his testimony for Aaliyah.
I made a ruling at the pretrial hearing that specific evidence of good conduct is not admissible unless you're calling somebody who is going to testify about his character. And there are particular rules that go along with that. But I specifically ruled that this was not permissible. It is certainly not permissible through someone else. I mean, if the defendant is going to testify about his life as a part of his testimony, that's one thing. But you cannot have another witness come in here and say that he grew up on the streets of Chicago and worked hard. It is just not permissible. And I frankly already ruled on it. So stop doing that, please.
Can I just address one other thing? You're not planning to reference his own upbringing. No. Just want to make sure.
Do you know about how much longer you're going to be?
Maybe a half hour.
All right. I just wanted to see if we're going to be able to start a witness. Okay, great.
Okay. May I, Judge?
Yes, go ahead.
Thank you. Ladies and gentlemen, let's talk a little bit more specific. Let's talk about each individual Jane Doe that you will hear from on the witness stand and what we anticipate the evidence will show. Ladies and gentlemen, the first charge that has been presented to you by the government has to do with bribery. Bribery, ladies and gentlemen, and it dates all the way back to 1994. Ladies and gentlemen, when you hear that testimony and when you hear how long ago the crime that they are alleged occurred, require them to prove the specifics to you because, ladies and gentlemen, use your common sense. If Mr. Kelly was involved in a crime back in 1994, would we be here today? Objection.
Sustained.
Ladies and gentlemen. Oh, go ahead.
Ladies and gentlemen, you are going to find that when it comes to Aaliyah, Jane Doe number 1, the government suggests that you're going to hear that she was pregnant and that was the reasoning for a false marriage. Ladies and gentlemen, Aaliyah, God rest her soul, she passed away. She's not going to be here to testify from the stand. Ladies and gentlemen, hold them to having a witness that is going to say that she was pregnant. Now, did she have friends that she probably talked to? Does she have family? Of course. But, ladies and gentlemen, there would be no evidence, no proof that any of that is even true. Now, I wish I could say that when Aaliyah takes the stand, she could tell you that herself. But instead, ladies and gentlemen, under the circumstances, under the way the government has chosen to charge Mr. Kelly with a very, very serious.
Sustained. The charges are what they are. Please talk about what you expect the evidence to prove. I will instruct the jury on the law. Go ahead.
Thank you, Judge. Make sure you listen to the few witnesses that they are going to have for the bribery charge. You'll see that RSK, which is the enterprise that you are suggesting.
Objection.
Overruled.
That Mr. Kelly was somehow involved in this illegal request of a state employee to change an ID. Listen to the very minute important details of that testimony, and we suggest that you won't hear the truth that will allow them to succeed on that charge. And if they can't prove that charge beyond a reasonable doubt, you ultimately will have to find Mr. Kelly not guilty of that charge. Now, ladies and gentlemen, you are also going to hear from Jane Doe number 2. Jane Doe number 2, ladies and gentlemen, you will hear had met RKelly. In fact, you'll hear that she met him initially, but it wasn't until, I believe it was about a year or so later, at a coffee shop. Ladies and gentlemen, you are going to hear that they exchanged phone numbers. They are there, and that she called Mr. Kelly. In fact, ladies and gentlemen, you're going to hear that they dated for 6-8 months. And when I say dated, she came to see Mr. Kelly often in different states. Now, you're going to hear how the way that she ended up getting to come and deciding to go visit Mr. Kelly was she showed up at a Nike store. The Nike store in Chicago up on Michigan Avenue. And that's where she exchanged phone numbers. Although I indicated they talked at a coffee shop, but nothing actually came about until Nike. Now, the government has told you, and they expected the evidence to show that Jane Doe number 2, she formed a relationship with Mr. Kelly because she had a friend that she wanted to introduce to Mr. Kelly, who was a good singer. Ladies and gentlemen, you also going to hear that when she ended up going to visit Mr. Kelly, you won't see a plane ticket for her friend. You won't hear testimony from that stand that her friend, ever sang for Mr. Kelly. No, ladies and gentlemen, that was a relationship that she formed and that ultimately ended. Now, when Jane Doe number 2, you're going to hear, and the allegations are that there was a sex tape video. In fact, the allegations are that she was exploited, is the word under the law. That Mr. Kelly intentionally and knowingly coerced her into having sex. Ladies and gentlemen, we believe the evidence will show quite the contrary. And that's why, ladies and gentlemen, we need to use your common sense when you hear about the relationships that Jane Doe number 2 had with Mr. Kelly. Now, you are also going to hear about Jane Doe number 3. Now, Jane Doe number 3, Mr. Kelly's charge in the indictment with regards to Jane Doe number 3 with secretly confining her. He is charged with confining her for a purpose of kidnapping her. Ladies and gentlemen, we anticipate that you're going to hear that she came to the studio in Chicago, Mr. Kelly's studio, in hopes of getting to know Mr. Kelly. Initially, she'll tell you it was because she worked at a radio station and her boss at the radio station wanted her to come and go find Mr. Kelly or interact with Mr. Kelly in an interview. The interview was declined. You were here. But she continued to talk to Mr. Kelly. And over weeks, it's not months, they decided they would get together. When she got on that plane, of which nobody forced her to, she ends up in Chicago and she does go to the studio. She says, well, ladies and gentlemen, we anticipate that you're going to hear that when she got to the studio, she was taken to one of the rooms there. In fact, the studio, you're here, it has bedrooms there. It has, I want to call it like a hangout room with couches. There were several parties that happened at those studios. And you'll hear that she was escorted or taken by one of the runners to the room to wait so she could meet and engage to talk to Mr. Kelly. Now, you're going to hear that she waited hours and hours. And then it sounds like she's going to tell you it was days where she was locked in a room, a secret confined room, that what the law says. And she couldn't do anything. She couldn't eat. She was starving and she was not able to get out. Ladies and gentlemen, you are going to hear. She will also tell you she was comfortable enough that she went and took a shower, which was not in the room that she was waiting for Mr. Kelly. She'll tell you, yes, she went to the bathroom. Again, not in the room. And she's going to tell you that she had her cell phone the entire time. Not only did she have her cell phone where she could have called the police if she was in some kind of danger or felt like she was being held against her will, there was a phone in the room. This was back when there was phones that actually connected to the wall. She also going to tell you that she used the phone. She'll tell you she called the front desk, the receptionist area, where the runners are, almost as many as 80 times. Where is Mr. Kelly? Where is Mr. Kelly? She also was hungry, and you'll hear that she ended up getting her Chinese food and the drink. She'll tell you that she didn't have any ice. There are reasons why I bring that up. The allegations are that Mr. Kelly, when he kidnapped her, when he locked her in the room, because I believe she's going to tell you the doors only locked from the outside in. Hold the government to that, please. I suggest that you won't see one picture or one other person tell you the same. So, ladies and gentlemen, the other part of the charges against Mr. Kelly with Jane Doe number 3 is that he engaged in fondling or touched her and she was drugged. Ladies and gentlemen, you will not hear her take the stand and tell you that she knows that she had any kind of sexual relations with Mr. Kelly. No, you're not going to be asked to make assumptions based on what she tells you. I believe the government said she woke up and there was some liquid coming from her private area. Ladies and gentlemen, don't let the government prove don't let the government prove a case to you or try to prove a case to you based on I think we had sex. It feels like I might have had sex with him. In fact, ladies and gentlemen, you're going to hear her tell you she felt and she believed she was drugged. Hold the government to that, ladies and gentlemen. Make the government show you beyond a reasonable doubt that that is in fact true. And when you see that this is a narrative, you won't be able to find Mr. Kelly guilty of that charge either. Now, next, ladies and gentlemen, I am going to move on to Jane Doe number 4. Now, you're going to hear not one, not two, not three, but I can't even count as high as the number of untrue stories that you're going to hear from Jane Doe number 4 on that stand. Ladies and gentlemen, she's going to tell you from her own mouth. She will admit that she's a liar. She lied to Mr. Kelly. In fact, she's going to tell you and admit that she was a super fan. She'll tell you since a young age, Mr. Kelly's music has been around her family, friends, and the neighborhood, and she listened to it, and that his music was everything to her. You're also going to hear her tell you that she was completely enveloped in her passion for Mr. R. Kelly, the singer. In fact, ladies and gentlemen, the proverbial word for groupie, which I don't, which we don't usually like to use, but it's a word, is an understatement when it comes. You will see Jane Doe number 4. Jane Doe number 4 is going to tell you about how she met Mr. Kelly. In fact, she's going to tell you that there was a court procedure and she heard that it was going to be in Chicago where she lived at 14 years old, and she wanted to get a chance to support Mr. Kelly. In fact, ladies and gentlemen, she's going to tell you that she went to the hearing every day. She skipped school. Mom and dad. Mom and dad didn't know about it. She lied to her parents. Excuse me, she lied to her mom. I believe her father may have passed, so I apologize. I'm not sure. But she'll tell you she lied to her mom, who she had a very close relationship with. She'll tell you so she could pursue her passion, Mr. Kelly. In fact, Jane Doe number 4 is going to tell you that she was even personally acknowledged by Mr. Kelly and that he had promised her a signature or autograph. You're going to also hear, ladies and gentlemen, that there was other women who were as supportive as Jane Doe number 4 of Mr. Kelly. They had a forum you'll hear on the internet for R. Kelly supporters. She met and befriended people from that forum. It will be obvious when she takes the stand that she possessed a special passion for Mr. Kelly. Now, what you're also going to hear, ladies and gentlemen, with regards to Jane Doe number 4, she wrote a book. She talked to several talk shows, one of which you will hear is a talk show that she was on that had nothing to do with Mr. Kelly. Ladies and gentlemen, why the media stuff is so important in this aspect is because you're going to see how Jane Doe number 4's story is like a snowball. It's small. I met R. Kelly. Oh, I saw R. Kelly. And it just gets bigger and bigger and bigger. The lies, the untruths that she attaches to herself and Mr. Kelly, you'll see them unfold.
Miss Becker, I hope this is a good time to break.
Sure.
I'm going to excuse the jury for lunch, so you can have a seat.
Thank you.
All right, folks, I'm going to excuse you for lunch. Again, please do not talk about anything having to do with this case, but have a good lunch and we'll be back here at 2:15. All right, see you then.
All rise. You may be seated.
All right, anything before we break for lunch?
No, Your Honor.
Miss Gannis?
No, Your Honor.
All right. How much longer do you think you have, Miss Becker? It's been going on a little while. As long as you want, it's fine. No more discussions about the law at all. But I am just trying to get an idea of when we'll get the witness on.
Judge, I talk slow, so.
Well, can you use the microphone too? That's all right.
Sorry, Judge.
That's all right.
Judge, I know I speak slow, and I'll speed up.
I don't want you to speak faster. And if you have more to say to the jury, I'm going to let you do that within the bounds of the rules. I'm really just trying to figure out scheduling, that's all.
25 minutes, Judge. We'll try to keep it at that.
Okay, and the first witness is?
Geronda Pace. And Your Honor, there may be one issue that we're going to raise before Miss Pace testifies. Are you still talking about Miss Pace in your opening?
I think we just...
Did we just finish? Okay, so Your Honor had previously ruled that evidence of the defendant's 2002 arrest and 2008 trial was not going to come in. However, I think the defense brutally attacked Miss Pace's credibility, and part of what she's going to testify to is that she, of course, met the defendant at the trial and attended virtually every single day of the trial. But most importantly, when she last saw Mr. Kelly, he assaulted her, and she then retained a lawyer to discuss what, if any, option she had. And ultimately, she reached a civil settlement with Mr. Kelly. However, she did not pursue criminal charges against Mr. Kelly, in large part because she had seen what had happened during the 2002 arrest and trial thereafter, and that greatly informed how she ultimately resolved those charges. I anticipate, based on defense opening, that she's going to be attacked again for pursuing the civil settlement, and it is going to be difficult to explain to the jury some of the reasons why she didn't go to the police.
Well, I don't know who is cross-examining her. Are you going to challenge the fact that she didn't go to the police? I don't know which one of you has the witness.
I do, Judge.
All right. I mean, just as a general matter, I made rulings pre-trial, some of them to protect the defendant. And I did notice that you were referring to that trial. I think I ruled that you should refer to it as a court proceeding, which is fine. But I think you just have to bear in mind, if you start questioning her about why she didn't go to the police about it, if that's one of the factors, it could open the door. I have not heard the testimony, so I'm not making a ruling on it now. But like in every case, you have to be mindful about the steps that I have taken to protect Mr. Kelly, and you can't use it as a sword. So I will be mindful of that ruling. They are subject to change if either side opens the door or something like that. So, all right, have a good lunch. I will see you back here afterwards.
All rise.
You can have a seat. Okay, is there anything before we bring the jurors in?
Nothing from us.
Just about another 20 minutes on the opening.
Yes.
Okay, great. Let's get the jurors.
Your Honor, just so you know, when the government calls our first witness, I understand that the CSOs are going to bring her through that door right there.
Yes.
All rise. You may be seated.
All right, jurors, I hope you enjoyed your lunch, and I hope you got the chance to warm up a little bit. We are ready to resume. Go ahead, Ms. Blankbecker.
Thank you, Judge. May I, Judge?
Go ahead.
Thank you. Ladies and gentlemen, just before lunch, we were talking about Jane Doe number 4. Ladies and gentlemen, the evidence is going to show that, yes, Jane Doe number 4 on one occasion did go over to Mr. Kelly's house. It was a party, and she was there with a friend of hers. She was invited there not by Mr. Kelly, but by someone else. That is the only time you'll hear, ladies and gentlemen, that she was actually invited there. Why do I say that? You're not going to see any text messages between Mr. Kelly and Geronda Pace. Excuse me, Jane Doe number 4. Ladies and gentlemen, you're actually going to hear that she was at Mr. Kelly's house uninvited with a friend of hers. Her friend is going to testify as well, and you're going to hear what happened when they went into Mr. Kelly's home and took pictures of themselves in the house. And I suggest you won't get to see any pictures of Mr. Kelly with Jane Doe number 4, other than the media might have taken some pictures. You'll see. You might see a picture, or he poses for a picture and gave her a signature, something to that effect. But never, you will not see and you will not hear about any text messages. Why? Because, ladies and gentlemen, remember, she is a self-proclaimed liar. And I suggest to you, ladies and gentlemen, that when you have someone on the stand who is a self-proclaimed liar, and what I mean by that, she is going to admit she lied about her age. And that's an important factor here, ladies and gentlemen, because she's going to be asked about that. Listen to what she says. Now, I also got to tell you, I'm here telling you what you're going to hear from the stand, but sometimes with Jane Doe number 4, you never know. So I anticipate that she is going to get on the stand. She's going to claim she had this magnificent relationship with Mr. Kelly until it was time to write a book. She'll tell you about her book until she found out that there was a lawyer who was advertising for individuals who, if they felt they were victimized by Mr. Kelly, call this number, and she did. That's what I talked about. That is what I mean when they say the Jane Does, they have motive. And Jane Doe number 4, motive is no different. Only we believe that it will be obvious when she testifies and we try to get her to stick to a story, she can't do it. And why? Why? Because when you tell the truth over and over again, it's easy. You come in here and tell you guys the truth. But when you hear the number of times she changed, even in the minute, I guess it's supposed to be minute, even some of the small details snowball. Ladies and gentlemen, you get to be the judge of the credibility, and I believe that when Jane Doe number 4 takes the stand, her credibility will be an issue. Now, I'm not next to talk about Jane Doe. Now, I'm next going to talk about Jane Doe. I'm going to skip 5 for a moment, and I'm going to talk about Jane Doe number 6. Jane Doe number 6, you will hear that she met Mr. Kelly at one of his concerts. Her sister had backstage passes. She went with her sister. They got to go in what's called typically the green room, which is where you'll hear. That's where a number of people go after a concert, whether it's to go do an interview, soundbite for radio or fans. She was there. She was ultimately exchanged phone numbers with Mr. Kelly. Remember, ladies and gentlemen, one of the elements in this whole thing, the whole enterprise, is that Mr. Kelly's people, and in fact, the indictment says his entourage recruited people, right? What you're going to hear actually that isn't always true. It's a nice umbrella. Hold on. It's a nice umbrella to put all the Jane Does, but ladies and gentlemen, to exchange phone numbers with Mr. Kelly himself, and she called him. You'll hear, ladies and gentlemen, that ultimately they had a dating relationship. In fact, you'll hear they had a dating relationship for quite some time, and ultimately it ended. Now, she'll give you her reason for why she believed it ended, like any other couple. Oftentimes, there are two sides to a story. But, ladies and gentlemen, when she takes the stand and she tells you about her reason for why she believed it was over, I believe that you're going to add her to the saying, Hell hath no fury like a woman scorned. Meaning, ladies and gentlemen, when Jane Doe number 4 testifies, she would tell you that she learned about the other girls the other women that Mr. Kelly was dating. And when she learned about that, she was none too happy. Now she's going to claim that she didn't know about them, ladies and gentlemen. But I anticipate what we anticipate, that you're going to get a chance to see text messages and messages where she is on them with other girlfriends of Mr. Kelly. But ultimately, ladies and gentlemen, one of the things that she's going to testify about is she's going to tell you that she believes that she is confident that she contracted herpes from Mr. Kelly. Confident. And what's even more interesting, and I hope listen to this testimony at this point, she's going to tell you that she knows exactly when she got herpes from Mr. Kelly. The last time she was in New York. She's going to tell you guys that that's when she believes she contracted the disease. Because, ladies and gentlemen, one of the ways you'll see that Mr. Kelly is here before you in New York is because of Jane Doe number 6 claims. Now, Jane Doe number 6 is going to tell you about her relationship. And Jane Doe number 6 is going to look you in the eyes and tell you that this is the man that gave her herpes. Well, ladies and gentlemen, you're going to hear from doctors, probably doctors, both sides. And when you hear what they explain to you about herpes in your mind, I hope you reflect back on what Miss Jane Doe number 6 said and ask yourself, does that make any sense? Use your common sense. We believe that your common sense is going to be a very important tool when it comes to Jane Doe number 6. Now, ladies and gentlemen, another interesting thing just to note, because it's a huge topic and something that's going to be asked about a lot regarding herpes. The individuals, the witnesses who take the stand and point to Mr. Kelly and say that that's the person that gave it that particular herpes to them. Wait till you see how confident they are. And again, ringing that bell and listen to the doctors, what they tell you about herpes, and then the number of witnesses there are on the stand, you'll be able to just cross them out, I suggest. Now, let's move on to Jane Doe number 5. Jane Doe number 5, you will hear, was a long-term girlfriend of Mr. Kelly's. You're going to hear that the way she met Mr. Kelly was her parents decided to take her to one of his shows. They went to the show. Her parents went as well. And during the show, you'll hear that Mr. Kelly has a part in his
They went to the show. Her parents went as well. And during the show, you'll hear that Mr. Kelly has a part in his show where people from the audience are allowed to come up stage and dance, or do what people do on a stage at a rock concert. And you're going to hear, ladies and gentlemen, that Jane Doe number 5, she was up on that stage. You'll hear that. And not only was she up on the stage, you'll hear about her dance moves. And ultimately, ladies and gentlemen, you're going to hear, as a result of that, phone numbers were exchanged and her parents were aware of it. You're going to hear that. Objection?
The objection is overruled. But please bear in mind that the rulings that I've made prior to trial. Let's move on to something else.
Thank you, Judge. You're going to hear that the way they're Mr. Kelly and Jane Doe number 5's relationship began. It began a lie. Now keep you all in suspense. You're going to hear about that when she takes the stand. You're going to hear and actually see what kind of relationship she had with Mr. Kelly. She was in an envious position, for lack of better words. She was super close with Mr. Kelly. You'll hear that. They did everything together, a lot, driving the car, going places. She was there. And then it wasn't until she talked to Mr. Kelly, and they, at that point, which was recently, Mr. Kelly had a relationship with Jane Doe number 5, but also another young woman, and they were friends. You'll hear Jane Doe number 5 and other women, they were all friends. But there came a point where Jane Doe number 5 drew a line in the sand, and Jane Doe number 5 told Mr. Kelly it was time to get rid of her. Not only that, you'll hear that she told Mr. Kelly she wanted her own place. And when Mr. Kelly told her he's not going to do that, the other woman is just as willing, and supportive as you are. He's not going to break up with the other girl. Not going to get this new apartment for Jane Doe number 5 to have by herself. Guess what happened? You're going to hear and you're going to see and you're going to hear she unraveled. No longer was she supportive. Was she close to Mr. Kelly? Instead, it was like the total opposite. And you're going to her talk about how I anticipated how horrible Mr. Kelly is. You're going to get to see the pictures as well, the happy times, the good times, and somehow you will see that Jane Doe number 5 won't have it. That is not the reality. She'll tell you that relationship, even though you see the pictures, you hear that we're out together, the other girls are, all the other women are, they're going to say, yes, they seemed like they were the closest. But wait till she testifies and wait till you see and hear the web of truth, confession, and unbelievability of that witness. Jane Doe number 5 is just another example, ladies and gentlemen, of someone who ended up having a motive. You're going to hear what her motive ends up being. And ladies and gentlemen, I suggest to you that when you hear her testimony and you put it in context and you hear the totality of the circumstances, you're not going to be able to believe her either. And if you don't believe the witness and there's a charge connected to that witness, you as jurors can say no. And I anticipate that will happen if you listen to all of the testimony. Now, I apologize. I'm slow, but I just want to make sure you hear every word and it sinks in. Now, ladies and gentlemen, what we have described thus far is the number of women that are after revenge. Revenge. That word is going to make sense when you hear their testimony. Now, that's a big word, big shoes to fill. But I think after you hear everyone's testimony, that word will ring true. Now, now you're going to hear all sorts of things throughout this trial from the stand, and I suggest that some things you're going to hear have to do with Mr. Kelly's choices and partners. In fact, ladies and gentlemen, you're not going to hear anyone take the stand who is a male who is listed as a Jane Doe or John Doe in the indictment. No, you're going to hear from a number of other people, including the John Does, about Mr. Kelly's personal sexual desires. Why, ladies and gentlemen? Well, ladies and gentlemen, there have been, you'll hear that there have been rumors. There have been several things like Mr. Kelly is gay. Ladies and gentlemen, we're in a court of law. You'll hear yourself whether he is gay, bisexual, heterosexual, who cares? Ladies and gentlemen, you're going to hear that some of the sexual activities that Mr. Kelly and his girlfriends engaged in, there were others that were involved. Does that strike that? You're not going to hear that anybody, any of the witnesses, any of the Jane Does objected to it. Yes, now you may hear about issues that they have with it, but doesn't it make sense? Strike that. Doesn't it make sense? And you're going to hear and make sense of the facts that a red flag doesn't get waved until when? The breakup. And then you'll hear Mr. Kelly, how Mr. Kelly enjoyed, wanted, was involved with men. Ladies and gentlemen, I suggest to you, we hope that as you listen to the testimony, you will see that that topic we call that fluffy. The topic of his sexual performance, it's a window dressing, and we hope that you see through that. Ladies and gentlemen, you're also going to hear about a number. And I'm sorry, I've moved past Jane Doe 5. Now you're going back. Huh? Hello?
What happened?
What happened?
Oh, I don't know. Go ahead and keep reading.
Yeah.
Okay, now you're going to hear about a number of civil lawsuits, and they will take the individuals who were involved with those, including Jane Doe's, will take the stand and tell you about it. And in fact, Jane Doe number 4 is going to tell you that she gave the money back. Ladies and gentlemen, like I said, I suggest you're going to hear some details that you're literally going to say that doesn't make sense. Listen to yourself. Let the alarms go off. You're going to hear that certain words, certain verbiage was used between Mr. Kelly and his girlfriends, Daddy. And somehow, ladies and gentlemen, you're going to hear from that stand that the word daddy has now become equivalent to the worst word you could ever think of. Daddy. I suggest to you, you'll hear nobody was complaining about having sexual relationships with Mr. Kelly, with Mr. Kelly. But now, ladies and gentlemen, we've got a word that I believe you will hear from that stand is a common word, a word you used oftentimes in sexual relationships, even non sexual relationships. In fact, you will hear that it's a common, nice way of referring to someone. Now, ladies and gentlemen, I am confident that that word is going to be slang in the mud. That word is going to be another rule. Ladies and gentlemen, usually when you get rules, how to play the game, for example, how to perform in your job, usually you don't get rule 1 at the beginning and 6 months into the job, you get rule 7. That doesn't make sense. So, ladies and gentlemen, when they start to talk to you about all of these horrible things that occurred, think about that and think about if that makes any sense. Now you're going to hear, ladies and gentlemen, that Mr. Kelly cannot read or write. You're going to hear, ladies and gentlemen, and you're from the stand that oftentimes, since he couldn't read or write, he literally came up with melodies and songs in his head. And ladies and gentlemen, you're going to hear that he worked crazy amounts of hours because his process as an artist is very different than maybe someone else's. And it's a time consuming process. In fact, you'll hear that oftentimes he worked through the whole night of the not by himself with his engineers. You'll hear that when he would go on tour and the tour bus, he'd bring his band and his engineers, and yes, his girlfriends, and yes, his friends oftentimes. But ladies and gentlemen, what you're going to hear is the different Jane Does are going to tell you about how much time they spent with Mr. Kelly. Ladies and gentlemen, you're going to see and you're going to hear the dates of different tours that he was on. Mr. Kelly was on the move on on a lot. On the move a lot. The studio was where he created mentally, and because he was a mental cerebral cerebral
Several.
how do you say it,
Several.
cerebral thinker, that's how he does his music. In order to go from the bottom to the top.
Can I see the parties at the side, please? Excuse me just a minute. First of all, you got to wrap this up. You've been going on for quite a long time. It's getting repetitive. Second, we're back into the world of talking about things that Mr. Kelly does or thinks that if he is not going to testify, they're not admissible. His process as an artist is completely irrelevant. I really do want to get going with some testimony. I'm asking you to wrap it up. Please don't do things that I keep telling you not to do. Is there anything else that you want to say?
I'll save this for after the court day, but I do have a concern with some of her arguments with respect to which our arguments with respect to the charges involving the exposure of a sexually transmitted disease. I think that counsel completely misstated that what the charge is, and making the jury believe that we have to prove that he actually is the reason for someone contracting an STD, and that's not the charge.
I've instructed them what lawyers say is not evidence, but I do expect the lawyers to follow the rule, and you just have to talk about the evidence it's going to show, and you really have to wrap it up. Go ahead.
Thank you, Judge. Ladies and gentlemen, the evidence that you will hear from the stand, the government has to prove to you beyond a reasonable doubt each and every element of each charge. We anticipate that there will be a lot of testimony coming from that stand, and I wish I could go through every little part of it, but that's what closing arguments are. Ladies and gentlemen, ultimately, the charges that you are here to determine that the government must prove beyond a reasonable doubt, we suggest that is going to be a very tough pill to swallow. Because, ladies and gentlemen, the United States of America against Robert S. Kelly, that is some big shoes to fill. And fortunately, ladies and gentlemen, we have you. You get to fill those shoes, meaning you get to listen and you get to interpret, and listen to the facts. And we are confident that if you do that, you will see there is no enterprise. You will see and you will hear that the testimony does not line up with kidnapping, secret rooms. So we ask you keep an open mind and listen to the testimony as it comes in. And that way we, as the defense, know Mr. Kelly will have a fair trial. And that is why we are all here today. Thank you very much, ladies and gentlemen. Thank you, Judge.
Thank you. All right. Are you ready to call your next witness?
Yes, Your Honor.
Your first witness?
Yes.
I'm stopping.
Stop right here.
Okay.
That's,
Woo, Lord.
Uh,
Oh,
that's
gosh. Nicole was just too long. Too
all right.
long.
All right, guys. We have just finished the opening argument. Tomorrow we're going to continue with the first witness, which is going to be Jerronda Pace, and we're going to do the examination, direct examination. So I'm trying to keep it as simple as possible so people can listen to it easily. So you guys have a good night. Bye-bye.
So we're on page
Bye.
102.
Thank you.
Bye.
Bye-bye, y'all.
Bye.
Bye-bye.